The appellant is Maybank Islamic Bhd, while the first respondent is LLB31103 Bhd, and a construction company, and the second respondent is guarantor. The dispute arose from Islamic banking facilities granted by the bank involving a murabaha overdraft facility and Islamic Bayi Taman Ajil. The party relationship was governed by letters of offer, a master facility agreement, and supporting asset purchase agreement and asset sale agreement. Under the murabaha structure, the bank purchased asset or rights or resold them to the customer at markup price payable on deferred terms. On 31 July, the bank granted total facility of 14 million, including 3 million MOD facility, secured by charges over 4 parcels of land and personal guarantees. On 8 December, the MOD facility was restructured under second letter of offer, increasing the limit to 5 million with repayment in lump sum within 12 months subject to annual review. This restructuring involved fresh EPA and SAA, and the second letter of offer supersede the earlier terms. MOD facility was reviewed annually. In May 2009, the bank issued a third letter of offer in reducing the facility limit from 4.5 million to 3.5 million. The first respondent objected and proposed alternative terms. Although a full letter of offer was issued, the respondent refused to accept it and rely on the second letter of offer. The MOD facility eventually matured and remained unpaid, while all other facilities were fully settled. The bank terminated the facility and sued for recovery of the outstanding amount. The respondent argued the MOD facility was invalid for Sharia non-compliance, that the facility reduction was wrongful, and tawif was not claimable after maturity. At the High Court, the bank's claims was dismissed, and later the bank appealed against that decision.
There are several issues arise in this case. The main issue is whether the Islamic financing facility, which is the Murabaha overdraft facility granted by Maybank Islamic Bhd to MIO Builders Nur Bhd, was Sharia compliant. The next one is whether the amount outstanding under the said Murabaha overdraft facility can be determined based on the defendant's admission of liability. Then, whether the Murabaha overdraft facility had matured and was required to be settled despite no asset purchase agreement and asset sale agreements being executed by the first defendant after 23 December 2004. Next, whether the maturity of the Murabaha overdraft facility is after 2014, which is 10 years after the letter of offer dated 31st July 2013. Next, whether the first defendant had breached the Murabaha overdraft facility by refusing to sign and accept the letters of offer dated to 28 May 2009 and 16 July 2009. Next, whether the plaintiff had the contractual rights to vary the terms of the Murabaha overdraft facility and or to effect a unilateral termination of the facility. Then, whether there is any outstanding amount payable to the plaintiff under the said Murabaha overdraft facility. Next, whether the plaintiff may impose with charges on any outstanding amount under the Murabaha overdraft facility in accordance with the R rate or 1% per annum as permitted by the Sharia Advisory Council of Bank Negara Malaysia. Next, whether the rate of ta'wid in accordance with the R rate can be imposed on the outstanding Murabaha overdraft facility after its maturity. Then, whether the plaintiff is entitled to unilaterally determine, vary, increase, or reduce the amount of facilities granted to the first defendant, given the fact that these transactions were based on Islamic financial principle. Next, whether the suspension and or stay of the Murabaha overdraft facility by the plaintiff in 2009 has any effect on the facility's maturity. Lastly, whether the first defendant suffered loss and damages due to the plaintiff's unilateral reduction of the Murabaha overdraft facility.
Moving on to the contention by both parties. First, the contention by the appellant, where the appellant had argued that the letter of offer dated 8 December 2004 had replaced the earlier letter of offer dated 31 July 2003, as it restructured the Murabaha overdraft facility by increasing the financing limit from 3 million to 5 million. Once accepted, respondents could not rely on the earlier terms. The appellant contended that the Murabaha facility was Sharia compliant, as it was structured as a buy-and transaction, which allows repeated sale and repurchase of the same asset and is recognized by the Sharia Advisory Council of Bank Negara Malaysia. The appellant denied using the same assets, arguing that the two facilities involve different subject matters. The appellant further argued that the Bank Negara Malaysia Sharia guidelines were not retrospective and could not invalidate transactions entered into in 2003 and 2004. In any event, any Sharia non-compliance would not render the contracts illegal, as the agreements were governed by the Contract Act 1950 and there were no grounds of illegality under sections 24 or 25 were satisfied. The appellant also claimed entitlement to ta'wid, following lawful termination of the facility due to non-payment, as such charges were contractually provided and permitted under Bank Negara Malaysia Sharia guidelines. Finally, the appellant relied on the consent order dated 27 March 2013, arguing that the respondents were stopped from denying liability. Moving on to the contention by the respondent. Respondents had argued that the 2004 letter of offer did not replace the 2003 letter, but had merely continued the original facility. Therefore, both letters should be read together with the original repayment and maturity terms still applicable. They contended that the facility was not Sharia compliant, as the appellant had used the same assets without fresh sale and purchase agreements, which violated Murabaha principles and rendered the facility unenforceable. Respondents further argued that the ta'wid was unlawful, as the facility had already matured and the appellant failed to justify the amount claimed. They also alleged that the appellant had wrongfully reduced the facility limit, causing financial loss and giving rise to a counterclaim. Regarding the consent order, the respondents argued that an ambition of liability cannot validate an unlawful contract, and the court was still entitled to examine Sharia compliance. Lastly, they submitted that the appellant's claim was barred by limitation, latches, and acquiescence. I will be passing to the next presenter.
Thank you. Now moving on to the judgment of the court. So firstly, we can see that Bank Negara Malaysia's Sharia guidelines and permits issued after Murabaha overdraft facility was granted does not apply retrospectively and therefore could not invalidate the transaction. With this, the High Court erred their decision. Second, we can see that the Murabaha overdraft facility was properly characterized as a buy al-inna transaction and not a pure Murabaha arrangement. Thus, guidelines applicable to Murabaha contracts were misapplied. Third, we can see that under Buy al-Inna, the same asset may be sold and repurchased multiple times without offending Sharia principle. Fourth, as the customer had admitted liability in the earlier consent order, it is binding and has stopped the respondents from disputing his liability except as to quantum. Fifth, we can see that an Islamic contract is not automatically illegal for breaching Sharia, as Islamic banking agreements are governed by the Contracts Act 1950 and are not void under sections 24 or 25 of the Contracts Act 1950. Now, we can see that the Murabaha overdraft facility, which is the Buy al-Inna, was valid and enforceable. So, we can see that the High Court erred in its holding as they said it was unlawful on Sharia grounds. Next, we can see how that Tawhid was contractually provided for and supported by Bank Negara guidelines. Thus, the bank was entitled to recover it. And finally, the respondent's counterclaim alleging wrongful reduction of facilities was substantiated and correctly dismissed. So, all in all, in this case, we can see that the Court of Appeal has allowed the bank's appeal with the global cost of 100,000 ringgit and dismissed the respondent's cross appeal, thus overturning the decisions of the High Court. In continuation with the ratio decidendi, so first, where the apex court decisions have conclusively settled the issues raised and the defense and counterclaim do not take a bona fide defense, the court is entitled to rule that the defense and counterclaim are bad in law without spending further judicial time. Next, we can see that if the defendant fails to lead any evidence or properly plead facts to justify a reduction of the claim sum, the court, applying strict pleading rules, cannot reduce the quantum or order any assessment, even if the claim appears excessive. Third, where the court is a running account accompanied by acknowledgements of liability, limitation does not begin to run as in a sterile or closed account. Hence, the defense of limitation would fail. Fourth, a trial judge's independent determination of Sharia principles without reference to the SAC as required by the statute breaches the decision. In such circumstances, documentary and oral evidence establish a prima facie case on liability and quantum, and if unrebutted, suffice for judgment. And last but not least, although Tawhid imposed in this case appeared to be oppressive and akin to disguised interest, the appellate court cannot raise any illegality on its own motion, nor reduce damages where the defendant's pleadings and evidence are deficient. And with that, I would like to say thank you and pass it on to the next presenter.
The decision in this case reinforced the structural integrity of Malaysian Islamic finance sector. The court definitively rules that Islamic banking agreements are commercial contracts governed by the Contract Act 1950. This is a critical development as it bars borrowers from citing Sharia non-compliance to avoid their contract and evade liability, a stance that aligns Malaysian jurisprudence with global common law standards found in UK. Procedurally, the ruling strictly enforced Section 56 of Central Bank of Malaysian Act. It clarified the civil court must refer question of Sharia interpretations, such as Murabaha guidelines, to Sharia Advisory Council. Civil judges are precluded from independent interpretations of this concept, ensuring that ruling remains technically accurate and consistent with regulatory standards. Finally, regarding ta'wif or compensation, the court upheld the bank's right to impose charges. While concerns regarding oppressiveness were raised, the legal outcome hinged on the evidence. The defense failed because they did not legally challenge the calculation methods. The precedent is clear. To successfully dispute quantum, as seen in Panorton, counsel must present concrete alternative calculation rather than relying solely on equitable argument. To conclude, Maybank Islamic and MIO Builders stand as definitive landmark ruling. By affirming that Islamic banking agreements are fundamentally commercial contract under Contract Act 1950, the court have effectively precluded borrowers from utilizing Sharia non-compliance as a technical ground to avoid their debt obligation. Furthermore, the judgment resolved critical procedural ambiguity. It explicitly mandates the civil court must refer questions of Sharia principle to the Sharia Advisory Council rather than attempting independent interpretation. It also clarified that regulatory guideline cannot be applied retrospectively to invalidate prior transactions. Ultimately, this case served as a strict reminder to practitioners. Admissions of liability create binding estoppel, and challenging the bank's claim requires substantial evidence. This decision significantly solidifies the legal certainty required for future Islamic finance litigation.